2012 DCL 3445, Trinidad Salinas versus Armando Villalobos. Mr. Guerra, you're here for the plaintiff?
Yes, sir.
All right. And for the respondent?
Your Honor, Grande Gonzalez and Sam Smith for respondent District Attorney Armando Villalobos.
For the record, my name is Manuel Pañales, and I've been assigned by the presiding judge of the 5th Administrative Judicial Region to preside over this case. And a few days ago, I signed an order for issue against Mr. Villalobos. Mr. Guerra, you're the petitioner's counsel. You have the opportunity to go first. Go ahead.
First of all, Your Honor, we have evidence to take care of this court properly stated that it wishes to see whether he's going to be served to prepare a defense on himself. The fact that he has attorneys here, this indicates, the court needs to indicate they can't have it both ways. If they are making an appearance and then they have waived citation, that is the whole purpose. This is for the court to hear the citizen, and the court puts it in a position where it is very informal kind of a setting for any citizen to come forward. And so that the idea, all the elected officials do not have to go through this. This is a protection that is only for the district attorneys, and the court can understand that. And researching, and I've done a lot of extensive research, as the court may know that I've gone through this before. But in doing the research as to why is it limited only to the district attorney and not all the other elected officials, and the objective was that they needed to make sure that citizens do not just on a whim because maybe they got a long sentence or from jail they start citing citations, and they don't have this procedure. And so this is kind of like a filter so that if they don't bother the DA, because you can see how many people will be bothering it, you will be constantly so the idea is that this is not for them to appear, and so by them appearing here, they can't have it both ways. If they're going to be making an argument, which they already have, they're technically making an appearance, and as far as we're concerned, we're done with this, and go ahead and do the second step, which is to go ahead and assign an adjoining district attorney, which in this case would probably be Mr. Rene Guerra, because Mr. Emmerman is obviously has been working for Armando for a couple of years. But at this point, the fact that they're here, there's no reason to even issue citation. They're making an appearance, they're making arguments, they're limited as far as the case that they cited, and I agree with it. As a matter of fact, that's a case that I was going to cite because it's a little bit on point, but the only problem with this case, Your Honor, is that issue with about this area. It talks the case that they filed, which is Wolf case. In that case, Your Honor, it's not the district attorney that was being removed, but was I think it was a school official or some other, but it was not a district attorney. And the case basically states that at this juncture that we're very limited to what we can do. As a matter of fact, the conditions in this matter. And I understand that there's also a motion to quash. The only person I tried to subpoena other people. Apparently, my server only was able to subpoena Mr. Lucio, and I noticed their objection to quash the subpoena, but and they're cited because of his constitutional rights. I think the proper case that needs to be cited is Wolf, because Wolf says that the citizen is very limited with regard to discovery. Now, if you study Wolf, we might have a problem with sending subpoenas, because this is not, it's a very limited, where we're trying to convince the judge, Your Honor, is that this is not a bad faith on the part of my client.
Mr. Guerra, let me
yes, sir.
Stop you there. It is your burden to persuade me, to convince me that citation should issue on this petition against Mr. Villalobos.
Yes, sir.
Tell me why I should order that citation issued.
Basically, Your Honor, it is the indictment is under the federal indictment that Mr. Villalobos is facing. It's very clearly stated, the grounds, and this is what's going on. As the court knows, in order to remove, there's got to be actions that happen in the term that he is now facing. I can't go back to 06 or back then, but if the court, and I gave a certified copy to this court, even up to the indictment recall that even up to May of this year, Your Honor, if you look at in the indictment on page.
So you're telling me that the mere fact that he has been indicted in federal court for one or more federal offenses, that that's enough to issue a citation?
I couldn't find a case, Your Honor, that aside from myself, where the district attorney continues to be indicted and continues to perform his duties. This honorable court, heard the evidence and decided that even though I had been indicted, there was no evidence. You actually, I guess, went through all the evidence. In this particular case, Your Honor, the fact that on paragraph number 13, page 7, says that he still committed these actions even up to, including May 3rd of 2012. And so that the mere fact that he has been indicted tells me that